Mum or dad, in the will of the last to die of them, has said this is what happens and that's the end of it. It can't be challenged, or at least there's been no cases yet where that could ever, and I don't think it ever could be challenged, under the family inheritance provisions. Used to be testator's family maintenance rules, but the family inheritance provisions are challenge a will because this is not property left in a will. So it means that a disgruntled son or daughter will be answered in an action to upset the will by the statement that it's not property under the will. They don't devise anything under the will. It's under the trust instrument. And for that reason, it serves well as a mechanism to ensure that the trust will be dealt with properly. Now, the effect of this is to take out of squabbling hands of the next generation shares that are inherently valueless, but used as a means of beating each other over the head with the trust assets. It takes that away because it can't affect the trust asset distributions. So it doesn't much matter who gets the shares if they can't influence the outcome of a trust decision. So they truly are worth only $1 or so. And that's a much better mechanism for doing it. Now, varying a trust to ensure that the trustee is as much bound to perform the the executor's or executrix's directions as the trustee of the estate would do, that is the executor or executrix of the estate would do, is unlikely ever to lead to a resettlement of the trust. And I say that for several reasons. First,
what are the consequences of resettling the trust?
Okay, if you resettle the trust, and this varies from state to state, but in South Australia, if you resettle the trust, that generally attracts ad valorem stamp duty, at least if the trust has land, shares or units in it, and if it has land, shares or units, the variation or resettlement of a trust will be liable for full ad valorem stamp duty.
So you can pay stamp duty on everything that's in the trust?
Yes, at the moment of resettlement.
Right.
Which is why it's important for the variation to a trust not to constitute a resettlement.
See, before you were talking about a trust deed as well. Can you just define what the trust deed is?
Yes.
Because I think you also mentioned making an alteration to the trust deed.
Yes, yes. The trust deed is the constitution of the trust. It is the instrument signed by the settlor and the trustee which sets out the terms of the trust and the powers the trustee has in dealing with trust property. So if we want to ordain a distribution pattern at the direction of the testator, the deceased mum or dad, then that's, unless the trust is set up this way from the start, that's going to require a variation to the trust. Because we want to take away the power of the trustee, a plenary power of the trustee, to decide who gets what in the future. We want mum and dad's will to say who gets what. So by taking away the plenary nature of the discretion and imposing an obligation to distribute as the testator directs, then that requires a variation to the trust. But it's not a variation that here and now creates a resettlement.
Okay.
There are some cases on this. I won't go through them, but broadly, what I've said is quite a large statement. But I think it's correct to say that only in rare cases or in trust deeds that are poorly drawn to start with, will there be a problem in stamp duty. If it was a resettlement, it might also create a CGT event, that is a complete creation of a trust on a resettlement. CGT event E1 is one of the capital gains tax events that would tax the trustee as if the gross value of the assets were realised as a capital gain. That's a consequence. So it's important to avoid a resettlement.
So the resettlement can incur stamp duty?
Yes.
And any capital gains that you've made from the time that the properties went in there?
Yes.
Till the time that the resettlement occurred?
Yes, any unrealised gains, that is.
That could be an enormous amount.
Oh, it could be an enormous amount, yes, yeah. We've seen cases, where there's been over 100 million where the amount of unrealised gains, post-capital gains tax assets in the trust, have grown to that number.
Now, trusts, how long does a trust last for?
Classically, until 1997 in South Australia, the effective answer was a life in being plus 21 years. And that's why we have South Australian trust and trust in other jurisdictions too, limited to the last lineal descendant now living of Her Majesty Queen Elizabeth II, plus 21 years.
Right.
Actually, it's a day less than 21 years. That was abolished in South Australia in 1997. But you still can't do it for a different reason. You cannot create what's called a perpetuity. So you cannot create a trust that lasts forever.
Okay.
That's against public policy. So generally what you provide is a trust that often lasts, is said to last for a life in being plus 21. And there's another reason for that I'll come to. But sometimes with power to extend it. There's always a power to bring it forward, but now you can have a power to extend it. And the reason why you still stick to this is you must have some limitation periods so you don't have a perpetuity. And second, the trust may own property interstate where perpetuity still exists, in those jurisdictions where it still exists. So if you own immovable property, for example, real estate in New South Wales, where there is a perpetuity period, there are several in fact, or New Zealand, or England, or other places, common law jurisdiction countries and places which are constrained by perpetuity periods. The rule against remoteness of vesting means it must vest, if at all, within a life in being plus 21 years. So you tend to make it so because in case the trust buys a piece of real estate in Victoria and New South Wales, it won't fail in that state because the proper law for administration of immovable property in other jurisdictions is the place of the jurisdiction, not South Australia. So in that case, you generally constrain the trust still to a period that's valid in all places where it's likely to trade. And the two pieces of immovable property that we're concerned about is real estate in another jurisdiction and a business in another jurisdiction. Goodwill is also immovable. So that, because you never know just how trusts are going to grow, you constrain it to the lowest common denominator of all the states and hope that if you do, the trust won't suddenly expire by a fluctuation of time. Many have.
And if the trust does expire, is at that point, which may be 120 years, at that point, that may trigger off stamp duty and capital gains?
Yes, it depends what the trustee says. In the case of capital gains, there is a vesting of the trust assets when its life ends. That's an ending of the trust. And depending on what the trustee says as to what will happen then, there will be a capital gain derived at that time because it's no longer in a trust, or the trust terms no longer bind it. In the case of stamp duty, a similar consequence will obtain if the trust is possessed of land or marketable securities, shares or units, in which case there is a vesting then and there of the trust property. Now often there's going to be an exemption that applies in stamp duty because it's the vesting in members of a family group, if it's established for a family group, and that often is exempt from stamp duty in this state and most states. But certainly CGT is going to be an issue. And of course, what you've then done is, if the trust comes to an end, then you have quite often the wrong people owning the assets. At least an unintended consequence. People have, in recent years, or last 10 years or so, started to recognise their trusts are starting to run out. A life in being plus 21 years. If you take the youngest person living on the date of creation of the trust, of Her Majesty Queen Elizabeth II, there's now several hundred issue of Queen Elizabeth II, I'm told, of lineal descendants. I don't know why so many. But there are quite a few, in this, certainly when it was King George VI, there are many more, that you can be sure that the youngest lineal descendant then living may not be living now, because it may have died before siblings of that youngest living person. So 21-year clock starts running then, and that's not so very long ago. We've had plenty of cases where trusts have reached their expiry date, and you can extend the life of a trust. The Commissioner's statement of position on resettling trust, he made a 2001 statement of principles on that. It's not law, but I think to this extent he's correct. It generally won't cause a resettlement of the trust if you're able to do it. And since 1997 in South Australia, you are able to do it. Generally not in other states. It often leads to the fact if you extend it, the state of judicial authority is that a settlement may occur, but not until the extended period expires, because that's when there is a vesting. If the vesting didn't occur, if you get it before the resettlement, then it's often the case that the resettlement would occur when the period runs out. There's a whole succession of cases in the United Kingdom. They came up in the late 50s, and they came up from estates that were settled in the First World War by the eminent domain who often settled matrimonial settlements on their new brides, and the brides started dropping off the perch in the 1950s, and people were desperately trying to extend the life of the trusts so that English estate duty wasn't paid. And there's a whole plethora of cases that deal with that, which is quite useful to us here in Australia. But that's generally the pitfalls. No, it's the big trap, if you run foul of it, in giving to the trustee an obligation to follow the wishes of the testator.
Campbell, I guess before you mentioned that the trust itself isn't really a person, it's not one that you can really shake their hands. What is the trust?
Mm-hmm. It's an obligation, no more than an obligation, imposed on a person who's possessed of property, which we call the trust fund, to deal with it in a particular way or for particular purposes. That's all it is, it's just an obligation. It doesn't have to arise by writing, unless it's land. The state legislation makes sure that arises if there's an interest in a trust by land, then it arises by reason of writing. But for things like shares and so forth, there's no necessity for a person possessed of shares to create a trust of them. There are tax reasons why that can be dangerous, but there's no equitable reason why that is so. So long as the conscience of the settlor, in this case the settlor as trustee, same person, must be bound. So he cannot recant the gift he's made of his own property.